Hello, everyone. Thank you very much for attending my session. This session is entitled The Legal Legitimacy of the Integration of AI in Decision-Making in International Arbitration. And the focus is on international commercial arbitration. So hopefully I'll elucidate some of the questions that you might be wondering about that come out of this presentation. So, as you know, AI has become quite widespread in different areas of arbitration, whether it's used for administrative purposes by lawyers or even by arbitral institutions for other types of tasks, such as research tasks. So the question really ensues as to whether arbitrators are allowed to use AI for decision-making. I think that's the big question that everyone's wondering about, given that we're already seeing a lot of AI guidelines that are being issued for the judiciary all across different jurisdictions. So I thought that it would be interesting to discuss this from the perspective of international commercial arbitration. So I'm not going to look into international investment arbitration. So in terms of the usage of AI and the percentages or surveys that we've seen so far, there was an annual survey done by a law firm in 2023, and it was their annual arbitration survey, and it was found that 28% of respondents had used ChatGPT in a professional context, whilst 30% of respondents had also used AI tools for text formatting and editing. Now, generally speaking, most surveyed arbitral institutions, because this is just an example of just one survey by a law firm, and other types of surveys, because Kluwer has also conducted a survey that I know of. Most respondents actually have said that they have used AI for administrative tasks, which is used for, I don't know, writing template for emails or drafting awards by arbitral institutions or checking on the validity or on different aspects of the arbitral award. So this is the main use that AI has been used for. Still not really answering the question of the extent to which it can be used in actual decision-making by arbitrators. Now, despite the fact that the use of AI is on the rise, in the same survey by the law firm, by BCLP, it was found that 62% of the respondents to the survey thought that AI tools should not actually be used for the generation of text for use in arbitral awards. So that's quite interesting. And I feel like people don't really know, or not that they don't know, but they're not really accustomed with AI. So as it's slowly being introduced as a tool, it's interesting to see how people or how different practitioners and different key role players are actually going to warm up to it. Now, there are examples of tools that have been developed for use in arbitration specifically, and others that you're familiar with that are more generally used for all types of I know, queries or tasks, such as ChatGPT or Gemini by Google. But then you also have specific tools that were developed for the use of law firms privately or arbitral institutions, such as Use AI, for example, or RBLex is used for third-party funding in international arbitration or international litigation. So you have different tools that are being used, and most probably in arbitration, they're privately developed for the specific arbitral institution or for a specific law firm. So the research question that I'm going to focus on, well, I have several actually. They're really twofold. So there are two main research questions that I would like to address in this presentation. The first one is whether it's legal, or to what extent is it actually legal in accordance with the current framework that we have to use AI as an aid for drafting an award or for reaching a decision in international arbitration by arbitrators. So, in other words, what does decision-making under the current international arbitration framework entail, and can arbitrators use any technological tools to help in reaching a decision, or AI tools to help in reaching a decision or drafting an award? Now, the second big question is that sort of evolves from this first question is how the current law is equipped to lead, to legitimize, or make sure that we have fair outcomes in using or harnessing AI in decision-making in international commercial arbitration. So first, let's delve into identifying to what extent it is legal to use AI in decision-making by arbitrators at the moment, as things currently stand. So we've seen the evolution and development of different ethical guidelines specific to arbitration, but also to ADR, ODR. Probably those who are in attendance here are very familiar with the ICODER and CTDR standards for ODR, as they have been the ones that have initiated these and have drafted them. And I'll start with those, actually, because I think, well, they're one of the first that actually came out. So in terms of the ICODER and CTDR standards for ODR, Standard 2 states that ODR systems are accountable. So this means that the determination of the relative control that is given to humans and to artificial decision-making strategies is actually the accountability of the system itself. So if a decision is made in an arbitration, let's say, and the ODR standards, the ICODER and CTDR ODR standards apply, then obviously this means that any problem with the use or the full use or the full reliance on AI for the decision by the arbitrator would mean that it's the accountability of the ODR system. Also, Standard 9 on transparency actually states that the ODR procedure or the ODR platform must clearly disclose the role and magnitude of the technology's influence on restricting or generating options and in final decisions or outcomes. So this means that the algorithm and the way that the decision was reached needs to be made transparent. And this is in case the parties or the arbitral institution decides to apply these ICODER and CTDR standards for ODR to the arbitration procedure. Now, in the arbitration world specifically, we've seen the development of several guidelines, and one of the most or mostly advertised or most publicized guidelines were the SBAM guidelines, which stand for the Silicon Valley Arbitration Mediation Center guidelines on the use of artificial intelligence in arbitration. So in terms of arbitral institutions, the SBAM was the first one to develop these guidelines, and they're quite interesting. So guideline 3 states that a disclosure of the use of AI or the use of the AI tool is not necessary if it's used by an arbitrator, unless due process or any applicable privilege are involved. Then the disclosure will be reviewed on a case-by-case basis. Guideline 6 goes further to state that the non-delegation of decision-making responsibilities is not allowed. So arbitrators are not allowed to delegate the decision-making of the arbitral award or the outcome to the AI tool. However, they can still somehow, it's not written this way, but you can discern from the rules by reading them. It's implied that you can still, or the arbitrator can still use AI as a tool for research or analysis. Guideline 7 of these rules, of these guidelines, states that if using an AI tool for case analysis or research, the arbitrator must allow the parties to comment on the source found by the AI tool and for the source validity to be verified independently. So far we understand that if an arbitrator is using an AI tool for decision making, it shouldn't affect, first of all, the arbitrator shouldn't delegate the decision making to the AI tool according to these guidelines. If the arbitrator is using, again, for decision making purposes, these AI tools, then they must disclose the fact that they have been using it, or if in any way it impacts the decision, because that affects due process, then there would have to be disclosure. But if they're just, I know, using it for pure administrative purposes that have no impact on the decision whatsoever, then the disclosure would not be necessary. And also, according to the last guideline I've talked about, under these guidelines, if the arbitrator uses information that was not mentioned by the parties through the use of the AI tool, then he must or she must allow the parties to comment on the source that is found by the AI tool. Again, I guess that's due to due process. Oops. Now, these are the guidelines that we saw that were developed specifically for ADR, ODR, and arbitration. But we've also seen recent judicial guidance that was also developed for litigation for courts by different jurisdictions. So I have a couple of examples here. I have the example of the judicial guidance for UK courts that was that came out, I think, last year or at the beginning of this year, forgot. But according to this judicial guidance, it's important to understand what AI is and its applications by judges, and that public AI chatbots such as ChatGPT do not provide answers from authoritative databases, that judges should ensure accountability and accuracy when using these AI tools, and that they need to take responsibility for using them. So this means that, again, similar to the SBAM guidelines and also similar to the NCTDR, the ICODER NCTDR ODR guidelines, it's important to ensure that the liability is clearly that of the arbitrator when using an AI tool, especially if it impacts the decision in any way. We've also seen, so the Council of Europe has also developed a few guidelines, and one of them was the European Commission for the Efficiency of Justice information note on the use of generative artificial intelligence by judicial professionals in a work-related context. And according to this guidance, AI should not be applied in cases where judges need to know how the answer was derived. So again, this relays us back to the idea of transparency. And in cases where the judge was expected to produce a genuinely self-derived answer. Moving forward, the DIFC courts also in the UAE issued guidance on large language models and generative content generators in dispute resolution, came out in 2023. And according to this guidance, again, when using AI tools in a judicial context, there needs to be, first of all, reliance, or there should not be reliance, actually. There should be a maintenance of accuracy and reliability by the judiciary, by the judge, and any generated content should be verified for accuracy, and parties should avoid over-reliance on the AI tool. And there is also the need for disclosure of the use of the AI tool. So according to this guidance, the use of AI technology should be disclosed at the earliest opportunity, given that this could produce any inaccuracies or biases, etc. So if we look at these examples of these guidances that were issued by the judiciary, it's quite interesting to note that there's no clear answer to see whether it is prohibited to use AI for decision making. So going back to arbitration and arbitral institutions, other than the SBAM guidelines, and I think the ABA, the American Bar Association, also came up with a few guidelines as well. There are no rules that were developed by the major arbitral institutions so far, which directly address the use of AI. At least they're not incorporated within their main rules on international arbitration for their procedures. Excuse me, sorry. We did see actually JAMS did develop artificial intelligence disputes clauses and rules, but a clause and rules in April 2024, but this does not really deal with the issue here. It just applies to AI disputes purely. And in an ICC report, so the International Chamber of Commerce, Court of Arbitration, obviously that's the most famous arbitration institution, or one of the most famous ones. In their ICC report on leveraging technology for fair, effective, and efficient international arbitration proceedings, they did mention predictive coding, but there's nothing else that they have dealt with regarding AI or decision-making using AI by arbitrators. So given this gap in the law, there's a question of whether the legal framework, to a certain extent, the actual like positive hard law actually deals with this. So as you know, the EU AI Act entered into force, or partly entered into force, in August of this year. And it is an interesting one because according to the EU AI Act, so as you know, it poses a classification of the strictness of different regulations depending on the likelihood of the harm that is caused by different AI systems. So arbitration somehow could fall under the remit of the EU AI Act because it does refer to ADR and ADR providers being involved. So according to Annex 3, Article 8A states that AI systems intended to be used by a judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts or to be used in a similar way in alternative dispute resolution are high-risk systems. So it's quite interesting to note the way that this has been drafted because it's not very clear, or it doesn't set very clearly whether decision-making or any type of action that, or any type of, I don't know, using the AI tool for, such as research, that would have an impact over the final decision of the arbitrator is not really dealt with here. So as you can see here, it just says that if you're using AI for research or interpreting facts and the law, then this is a high-risk system. It's not prohibited, it's just a high-risk system. So this really, begs the question of whether decision-making here can be, whether an AI tool can be used to assist in the decision-making process or the decision-making itself. Because I don't know, research or interpreting facts and the law could have a direct impact over the decision. So the question is, does that mean that the EU AI Act is actually saying that you can use AI for decision-making in arbitration? It's not prohibited? And would this just be a high-risk system? Now, Article 6.3 of the same Act also provides that you can use AI for insignificant tasks, such as administrative tasks, and that could be in the context of arbitration or ADR, generally speaking, as well. So this is the EU AI Act, which is one of the most important pieces of legislation, I would say. that deal with AI and its regulation. And yeah, it's interesting to see what approach it has actually undertaken to deal with this issue. So it really opens up the door for many, many questions that I'll address towards the end of this presentation. Now, for those who are familiar with international commercial arbitration, you know that you have the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958, which is the main or the key piece of legislation that applies, that holds the international commercial arbitration system together. And it's an old statute. It's obviously an old convention. So the question is whether the use of AI in decision-making by arbitrators would have an impact over any of the provisions that are imposed by the New York Convention. I'll just take you through it very quickly. According to Article 1(2), an arbitral award is defined as it shall include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies. So obviously this is 1958 when it was drafted, and it does refer to a decision being made by arbitrators. So it really is very ambiguous, because the arbitrator can use an AI tool to make a decision. And it's the arbitrator's final, decision that, would be the one that could be interpreted as being made by the arbitrator. So it does leave that room for ambiguity as to whether the arbitrator can use AI tools or not. Another article or another provision within the New York Convention is Article 5(1)(d) and E, actually. So two different provisions that deal with the composition of the arbitral authority or the arbitral procedure being in accordance with the agreement of the parties, or failing such agreement is not in accordance with the law of the country where the arbitration took place. So actually, this could have an impact. So if, for example, the legislation of a specific jurisdiction does not recognize the use of AI as an appropriate way of making a decision, or as a tool to make a decision, then this could invalidate the arbitral award. So to a certain extent, this is how it could impact. This is just one example of many of how this could impact the validity of the arbitral award, where AI was used to make the decision. So according to other ancestral instruments for the governance of international commercial arbitration, there's emphasis on the decision being made by arbitrators. But again, I think that the question is much more intricate than this, because at the moment, as we can see from the way that the EU AI Act's provisions were drafted, the question is really, if someone or an arbitrator or a judge uses AI as a tool for decision-making, does that really mean that they're delegating their decision-making duties to the AI tool? Or is it simply a tool that is being used? So the liability lies on simply the arbitrator. And then the decision is made by the arbitrator eventually, even if they used the AI tool. So it really opens up questions with regards to that area, which is the delegation of justice idea. Anyway, just moving on very quickly to domestic jurisdictions. Why am I talking about domestic jurisdictions when we're talking about international commercial arbitration? Well, as you've seen from the New York Convention, and as you may know, these tools are quite short, and they actually refer us back to the validity of arbitral awards or agreements, etc., that need to be in accordance with domestic law. So, and you've seen it from the wording of the provisions that I've just discussed. So just to give you a few examples from domestic jurisdictions and how they perceive the use of AI in arbitration, I think that the UK is one of those jurisdictions that seems to have a bit of a more open approach towards the acceptance of the use of AI, perhaps not directly for judicial or arbitral decision making, but it has an open-ended, let's call it that, an open-ended approach towards this matter. So just to give you an example, so nothing from the legislation itself, but there was a project that was coordinated by the Ministry of Justice and the Master of the Rolls, Sir Geoffrey Voss, and they created the UKJT, the UK Jurisdictional Task Force, Digital Dispute Resolution Rules. And these are rules, they're not a law, they're not a statute. According to these rules, in one of the provisions that they have, apparently you can use AI for decision making, and that would be considered to be valid according to the rules. And they also say that it's in compliance with English law on arbitration. So quite interesting to note this approach. In terms of other jurisdictions, and more particularly civil law jurisdictions, are a bit more closed off to this. I think, so for example, in French law, it only recognizes human arbitrators as producing valid arbitral awards, but it still opens up that question. It's the human arbitrator making the decision, but using an AI tool. So does that mean that the arbitrator is making the decision, or is it the AI tool? So it opens up, that sort of question here as well. And also, China issued guidance for generative AI service providers. And I know that in China, there have been a few arbitral procedures. I know of one specifically, because I read about it, where AI was actually used for decision-making in the procedure. So what's the final answer, or how do we discern whether it is legal to use AI in decision-making by arbitrators in international commercial arbitration from the analysis of these instruments that I've talked about? Well, so far, if we group them together, I actually came up with 4 points. First of all, it's clear that there should be an avoidance of the delegation of decision-making to AI. I did put a question mark though there, because it's still not clear to what extent. But anyway, given the guidelines and the current law, this should be avoided. Question mark, should it though? What does delegation of decision-making entail? Because for example, in arbitration, the drafting of arbitral awards is sometimes delegated to the arbitral secretaries. So is delegating it to an AI tool simply the same? Another point to note is that there's a consensus, or at least from the guidelines and the legal instruments that I've analyzed, that the use of AI can be used in arbitration for administrative and research tasks. Not clear again to what extent that has an impact over decision-making. And the third point is that there's an obligation for independent checks on the AI output or response by the arbitrator, and obviously by the arbitral institution, but the arbitrator first. And perhaps to a certain degree, there needs to be disclosure of use by the arbitrator to avoid liability. So in conclusion, I guess, my analysis shows that you can use in arbitration, as an arbitrator, AI tools in decision-making and award drafting, if using the AI tool for administrative tasks and research. I mean, the catch is that there's no prohibition from any piece of legislation in using AI tools in decision-making. It's all guidelines. So it really does open up that big question. And we've seen it again with the EU AI Act that, considers it as being of high risk, but there's no prohibition against the use of AI for decision-making, at least not clearly. So I might be saying something very controversial. But yeah, there's no clear prohibition against the use of AI in decision-making in international commercial arbitration by any legal instrument at the moment. Obviously, there are limitations and there are legal consequential issues on the arbitrator if they use AI directly or solely for decision-making, or I don't know, they completely rely on it for decision-making. And that, first and foremost, could be inaccuracy, bias to a certain degree. We've seen it with the Compass case in the US. And data protection confidentiality, if they're using a public platform that was not really approved by the arbitral institution or the parties. But mainly, yes, that would lead to the liability somehow of the arbitrator. So in terms of future developments, there are obviously still different questions here left unanswered on whether arbitrators can use AI for decision-making in international commercial arbitration. And the other question, if you remember, the other research question that I had was whether, or to what extent, it's fair to actually use AI in decision-making, given that the current legislation seems to a certain degree, not prohibit it. I don't have a direct answer to that. I can say that it definitely opens up questions with regards to what delegation of justice means. So yeah, I think that's my answer so far. But also, if we look at other trends in decision-making, in arbitration or in dispute resolution, generally speaking, and we see that actually different norms of justice or different norms of justice that we're accustomed with, such as, I know, the right to oral hearings or the right to having a reasoning in your decision or arbitral award is changing through technology. So for example, for those that are familiar with blockchain-based dispute resolution, so with the platform Kleros, you can see, so they call themselves to be an arbitration. To a certain degree, they might be, according to the law. I think this is debatable. But they did come up with an interesting procedure that is solely based on, based on the blockchain ecosystem, where decision-making is done in a different way to traditional arbitration. It's done by jurors. There's an incentive system where you have to make sure as a juror that you go with the fair flow. So making a decision that is considered to be fair. So that means that it's a majority of jurors that are making a fair decision together, and you'd be sanctioned if you go against the flow as a juror. And also, it's the decision itself in Kleros is based on a yes and no answer. There's no reasoning that is given there. So this is quite different from what we're used to, for example, in traditional arbitration. And the execution of the outcome is also automated because it's fully based on the smart contract on the blockchain-based system. So it even though it's not directly connected to AI and decision-making and traditional arbitration, it does show, and Kleros did become quite a popular platform, and it's clearly to a certain degree, I think, shaping new ways of seeing how dispute resolution processes such as arbitration could evolve in the future. And that's specifically for small claim values. And we can see actually different procedures that are being created, such as, for example, by the SIAC, so the Singapore Arbitration Center, created a streamlined procedure for smaller value cases, which, again, has adopted specific procedural specificities, such as not giving, for example, the parties the opportunity to have oral hearings. So this is all feeding into this trend of how different procedures, for example, SIAC is, it does involve arbitration procedures, how these arbitration procedures are actually being shaped by the need for more efficiency, and how they can be aided by technology, and how that is actually impacting different aspects or different norms of justice. And eventually that could also impact decision making. And the Answer Trial Work Group 2 has also worked on the Speeder project, for those that are familiar with it, for basically dealing with smaller value disputes and for having like a speedier procedure for these disputes. So lots of food for thought there. I would also recommend you go and read more about it. I'm happy to explain it if there are any questions about it. But yeah, so just to give you the final answer, I don't think I have a final answer, but I can give you my preliminary answer on what the answer to the question whether arbitrators can use AI for decision-making in international commercial arbitration. The answer is probably to a certain degree. There are no laws that prohibit against it. We're seeing a trend with the evolution of the use of technology and making or shaping these proceedings to become more efficient, less cost-effective as well. And is it fair to have legislation that does not prohibit against the use of AI for decision-making by arbitrators in international commercial arbitration? Well, I think this is where my next paper lies, so I'll probably tell you about it maybe in the next Cyberweek next year. Thank you very much.